Welcome to Freight Beat, a podcast from the Transportation Intermediaries Association. I'm Merritt,
And I'm Patrick.
and every week we talk with the people who shape freight, logistics, and how this country moves. We are recording this one fast because last week a jury in Dallas County returned a verdict of about $604 million, a nuclear verdict, some are saying, in a case involving a broker, a carrier, and a fatal crash. We asked our members what they wanted to know, and most of this episode is their questions.
Our guest today is Craig Helmreich. He founded Helmreich Law after more than 20 years at Scopolitas, and he works on contracts, cargo claims, and risk for carriers, brokers, and shippers. He's also a TIA member. Craig, just to clear things up, you are not counsel in this case, and nothing here is legal advice for anyone's specific situation. So welcome to Freight Beat.
Thanks for having me. Glad to be here.
So, Craig, just start us right at the beginning. Let's just dive right in. What was this case, and what did the jury come back with? Give us the background, please.
Sure. In very broad strokes, this is a multiple fatality case with significant injuries for the people that survived. It's an accident from roughly 5 or 6 years ago. It takes a long time for this stuff to filter through the courts. It's an advisory opinion. I want to make sure nobody misses that fact, that this is not a judgment that has been rendered. It's a step before a judgment. So a jury has come back with these numbers, and then it's up to the court whether it accepts these numbers or whether it changes these numbers. And it's still subject, obviously, to post-trial motions and appeal. I suspect there will be significant changes in this case, but broad brushes, fatality, multiple fatality case, really bad situation, something none of us ever want to see. There's a broker involved, there's a carrier involved, there's multiple third parties.
Okay. So when the jury kind of came back with their verdict, I suppose they broke it down in a very interesting way. They put 45% of the, I guess, blame or cost on the driver, 32 on the carrier, and 23% on the broker. But that broker is looking at most of that payment of $604 million, most of that judgment.
Really, all of
really?
it.
Okay.
The way
Oh,
that
yeah, okay.
the way that Texas law works is if your responsibility exceeds 50%, then you're responsible joint and severally for the entire amount of the judgment. And although you did mention the finding that C.H. Robinson was 23% at fault, because the jury came back with a borrowed servant decision that basically said CH had so much direction and control over the driver that CH is then responsible for the driver's 45%. It gets added to the 23%, and now you've got 68%. So you're over 50%. So the entire amount then can be collected from CH. So if this stands up the way that the jury put it in, it's not just the $129,000 number that CH would be looking at. It would be all 604.
So obviously, this is a very specific judgment, a very specific jury, at a very specific court, obviously in a very specific state. But I'm just kind of curious, that 50% threshold, is that unique to Texas law, or is that something that might be seen elsewhere in the
No,
country?
there are a handful of states that have the same kind of a mechanism. It is a good thing to point out. The trade press is talking about this because it's the first giant decision after Montgomery, and people are acting like this is going to chart the course of our industry. I think this case is a good reminder of the things that we need to pay attention to, but I do not think that 10 years from now we will be talking about this case in the same way that we will be talking about Montgomery. I think this case will get changed. I think there'll be some lessons learned from this case, certainly some things we should pay attention to, but I highly doubt this is a case that we are talking about with the same kind of importance as Montgomery.
So, a member, I want to jump into of the first question. One of our members actually sent us and asked. Every headline, like you said, calls this the first nuclear verdict after Montgomery. But our members read is that Robinson got hit on vicarious liability for controlling the driver, or this borrowed employee is what I read, which is unique and different than what many might have taken away from the Montgomery case in the first place. So which is it? Do brokers need to be more worried than they were in May, or is this a situation in which the broker, did something unique that they should not have been doing? Can you talk more about like how they defined this borrowed employee kind of
So we
concept?
don't have a ton of information about this case, and this is one of the unfortunate things that happens in jury decisions. When the judge makes a decision, they usually write up a very detailed, reasoned opinion that tells you why the decision came down the way that it did. And you don't get the same kind of details with a jury decision. And so we're left kind of waiting for the plaintiff to tell us what they think happened, and the defense attorneys to say what they think happened, and people who are in the know about the case to leak things. So we have a little bit less information now about exactly what was done here that drove the borrowed servant decision. But we do know that the driver reported to both the motor carrier and the broker that he was too sick to continue. But then did continue for some reason. And so you might find that there are some facts in this case about somebody somewhere telling him, keep going, this has to be delivered, or putting a penalty in, or stressing. There could be all kinds of circumstances like that. I want to be clear, I do not know the exact circumstances in this case, but the lesson to brokers from this case should really be about control, and that the exercise of too much control is what leads to decisions like this one. We have to all be conscious of Montgomery, and carrier vetting. We've spoken with 202 clients about how they should be doing their carrier vetting post Montgomery. And in each one of those discussions, we've said, don't forget about vicarious liability, about borrowed servant. Like, there are two pieces to the current plaintiff attack on brokers. One of them is carrier vetting, and the other one is direction and control, leading to these vicarious liability and borrowed servant type decisions.
The term borrowed servant, I mean, is that something you're seeing more and more in cases like this? Or is it just kind of, I don't, I've, again, this is something I've never really heard before, but I am not a transport lawyer, right? So, I don't, is this a pretty common tool in trying to identify liability from plaintiffs, or is it something kind of new within this arena?
No, it's been the main attack. In fact, during the F4A era, as I'll call it, the last 10 years when we had the ability to use F4A as a shield against these claims, plaintiffs got really creative and tried to develop this borrowed servant or vicarious liability theory because it was a way to get around F4A liability. So we've all been defending these cases using facing this exact theory for the past decade. State by state, the language changes. Vicarious liability is the broader way to describe it. In Texas, they call it borrowed servant. It comes out of their construction case law for the most part. And actually, there's some cases involving doctors and independent contractor nurses, and the doctor gets to direct the nurse exactly how to do the job. And it's that exact type of direction that then makes the nurse a borrowed servant, even though she's an independent contractor. Um, so um, it's something that's newer to transportation. And ironically, the existence of the F4A shield kind of pushed the plaintiff's bar to kind of find it. Now they've found it, they're all aware of it, and it's what they're pursuing as one of the two prongs of attacks against brokers currently.
Just real quick. So you're saying that before Montgomery, this was something that was identified, but now we're seeing the ramifications post Montgomery. So was it successful pre Montgomery, and this is just like blasted out because of the timing? Or, what would have happened pre Montgomery with something like this?
Exactly the same. The thing that's ironic about all of this is we're paying more attention because of Montgomery, right? And everybody's trying to read the tea leaves because Montgomery now puts the tea leaves into greater focus. But this case is pre-Montgomery facts. It's pre-Montgomery litigation. The bulk of this case was litigated before Montgomery, and really it's just timing. It just came out now.
Interesting. So, like, just one last thing. I'll try to keep this short, but like beforehand, like if this had happened in 2025 before all of this, people would have been like, "Whoa, I wasn't taking this borrowed employee thing as very seriously. Now I should." That's kind of what the result would have been. It would have been the same exact judgment. You think the same amount of money and everything?
I do think that's true. I will say this: there's things about the amount of money in this case that make no sense, and so saying that it would have come out the same requires the same Uh, oh boy, how do I say this without being inflammatory? Uh, an old partner of mine, Mike Langford, a wonderful guy, a great mediator, always talks about the village of idiots theory with juries. And you never know when you're going to seat a village of idiots. And sometimes that happens, and sometimes you get a ridiculous result because of the exact jury that's been seated. And so saying that this would have come out the same way before requires the same individuals to be seated in the jury box with the same crazy ideas. There are no economic damages in this case. And this is a little bit technical, but I think everybody should understand how crazy parts of this case are. There's no lost wages. There's no medical bills. There's none of those hard numbers that are always present in the case. This is 100% pain and suffering and mental anguish. Texas does not look fondly upon large decisions that are all pain, suffering, and mental anguish. You have one person in this case awarded $200 million for the pain, suffering, and mental anguish that happened before they passed away in the accident. Um, that's a lot of money for that type of occurrence. And so I think there are some things about this case that are relatively unique, that don't have anything to do with transportation, that have to do with who was seated in that jury box, and them wanting to compensate people that experienced a horrible thing. That there's significant loss. Nobody wants to make light of the terrible things that are part of this case. Um, but there are parts of it also that just don't make sense.
Hmm. Okay. So speaking, or kind of going back to something you were talking about before, I'm curious. This is from obviously our main audience is brokers. You talk about control, obviously, the idea of the borrowed servant. What kind of things is a broker doing in their day to day that maybe they don't even realize might trigger a plaintiff's lawyer to hold up as controlling a driver directly? Are there things that they're just happen to do within their own workflows that are perhaps accidentally too onerous on that carrier?
Yeah, I want to be careful that we don't give plaintiffs' attorneys a roadmap to attack brokers. The vast majority of our clients are brokers, and they will all murder me if I dictate the exact roadmap that gets used against them. But I think what brokers need to be thinking about is, are we monitoring what the carrier does? Or are we directing and controlling and influencing what the carrier does? And you'll see this is not giving away any secrets, right? Some of the trade press is already talking about check calls and tracking. And I don't have any problem with check calls that are passive, that just get an update on the status. Where are you? When do you think you'll be there? Kind of things. If we start telling a driver who tells us that they're too sick to continue, that they have to continue, I imagine that that is part of what happened in this case, and might be the reason why the decision went against the broker here. And so I think anything that can be used to say that we've directed and controlled and pushed the carrier, I worry about contract provisions that say you have to be on time, no exceptions. And then somebody tells me I'm out of hours of service because I was in a traffic situation for the last 3 hours and I can't get there. We definitely can't have brokerage employees saying, I don't care, you have to get there or you're not getting paid. Um, we have to worry about all the details that we put in our load confirmations. Sometimes the contract doesn't say very much about what you have to do, but a load confirmation will have 150 bullet points in it that give explicit details about all kinds of things that you need to do and fines and penalties if you don't do them. So it's all a trade-off, right? Like some of this is a business reality. As a broker, you need to deliver the level of service that your shipper customer is requiring of you. And so sometimes you don't have much of a choice. Now, interestingly, we've been able to get some contract terms in with shippers lately that say, shipper, you'll indemnify us if your requirements get us sued. And shippers have been saying that makes sense. And then I can say it's a shipper requirement that we have tracking. It's a shipper requirement that we do check calls. It's a shipper and so it's a shipper requirement that we meet a delivery window. And so if we can get a contract provision in that says that the shipper will indemnify us, that can be one of the most valuable things in our entire broker shipper agreement. Because unlike a broker carrier agreement where the carrier might not be able to honor its and the paper might not be worth, the indemnification obligation might not be worth the paper it's written on, if you have a one truck motor carrier that's indemnifying you. But if you have a Fortune 500 shipper that's indemnifying you, the paper is definitely the indemnification is definitely worth the paper it's written on.
Interesting. So I want to just make sure that the questions that we were sent were answered, and this might be a little bit redundant, but someone asked, courts seem to be moving towards expecting brokers to consider driver level specific safety information. But the minute you're looking at the driver, you're arguably closer to controlling the driver. So if a broker knows which driver's on the load, should they review that driver? And what would they review in that review? Or are you just better off not knowing? I think
So
that's yeah.
Yeah, this is a super nuanced question. It's excellent. So I love to know the name of the driver on the load. I love to give that name to the shipper because in my practice, half of what we do is cargo claims and cargo claim liability related. And we can stop a lot of the theft if the wrong person and the wrong carrier shows up and the shipper polices that for us. So I love to know the name of the driver. I love to verify that the driver is who they say they are at destination or at origin. Um, uh, I don't love anybody looking at the driver's motor vehicle history, right? Because then we're doing the motor carrier's job for them. And so there are some things that I want to look at with a driver. Some of the wonderful tech platforms in the industry have some driver related information services, but they are green light, red light based. And so does the driver hold a valid commercial driver's license? Yes, no. It's not showing you the history. It's not showing you moving violations and that kind of thing, but it's saying this is a CDL holder with a valid license. And that level of checking, I love. I think it's excellent. It allows us to say that we've been reasonable in our due diligence, but it's not the level that rises to doing the motor carrier's job for it that would lead to potential vicarious liability.
So another kind of question from a member. This is someone who he does all the standard things, right? He tries to go above and beyond. He tries to make sure he is doing everything correct and kind of keeping liability away from him. But in his view, high value goods on straight box trucks can take constant communication. A flatbed going to a construction site takes communication. He's not telling anybody to hurry up or run past their hours. He's not routing them or sending maps or telling them, what road to take. But he does talk to drivers on nearly every road to serve them to make sure they are where they say they are, like you were saying before, right? The check call sort of a thing. And verifying they speak English. And when the carrier is an owner operator, this is also a wrinkle to it, right? They're also the dispatcher. So his question is, what's the practical advice you might have for maintaining that operational distance you're talking about? Because oftentimes in these situations, that's just the way you're saying is almost impossible, I suppose.
Yeah, it's the business reality of transportation, right? We're
Right.
going to be talking to drivers. We're going to be communicating with drivers. You'll hear some people in my industry, some lawyers pitch something that could never be done operationally, and it drives me insane when they say only talk to dispatchers. And you pointed out, right? One man, one truck, maybe his own dispatcher. There is no additional dispatcher. And some of this is a distinction without a difference to me, right? Because if you tell the dispatcher that truck has to be there, no questions asked, 10 minutes from now, I don't care if they have hours of service left, you still have the same problem if you say the same thing to the driver. You're exercising the same kind of pressure and control that we want to avoid. And so the distinction that I rely on is passive versus active. Am I monitoring? Am I getting information that I can then communicate to my shipper customer, or am I trying to drive behavior? And you pointed out a couple of the things that are definite no-nos, right? Like we can't tell them the route. We can't tell them exactly how to do their job, just like you wouldn't tell them how to strap something down. Unless the shipper gave you strapping instructions because it's a unique item and you passed along the shipper's instructions verbatim, right? Then we're just handing along shipper requirements again, which I can live with 100% of the time. Um, but we don't want to rise to the level of telling a motor carrier how to do its job. Uh, and routing is probably the most clear example of that.
You talked earlier about tracking tools, which seem a bit more passive than even do check calls, things of that nature. Like I remember at Capital Ideas, I believe it was last year, I saw a tool that basically taps into all the publicly available like traffic cameras, and it will scan the truck driving by for its ID number, right?
Right.
I mean, are things like that? I don't know. It's a little more passive. It's just publicly available tools that you're kind of plugging into a tool you own. Does that feel? Do you feel? I guess like that's the thing to kind of help avoid that side of liability as far as telling the driver where to go and that sort of thing, because you're just watching. You're just kind of making sure they are where they are.
That's right. And those tools, the GenLogs tool in particular allows you to do additional like high level vetting, right? And you can see, has this truck been in this area? Is it close enough to pick up this load? Is the truck showing up a half an hour before it should be picking up in the right zip code? And so a lot of that tool, a lot of my clients are using as fraud prevention and kind of as additional levels of carrier vetting. And I'm fine with all of that, right? Like it's just one more tool, just like Highways ELD link gave us visibility into things we didn't have visibility into before. Is the truck in the right area? Do they have the number of trucks that they say that they have on the road? Do they have available capacity? Um, and so all of these tech tools are really cool to allow brokers to protect against people who aren't who they say they are, who are committing to moving more loads than they have capacity for. So it's going to be double brokered. You can get visibility into all of that stuff. And I'm not worried about vicarious liability from any of those tools.
So my next question is kind of just about, speaking of things that are publicly available or what, brokers are supposed to rely on in their decision making. One thing that's rocking a lot of people's world when it comes to this is that the carrier had a satisfactory rating going all the way back to 2014. It was reaffirmed as recently as April and had run a couple hundred loads for the broker without any problems, but the jury still found liability, and it saw on that these records were not public. So what is a satisfactory rating even worth now? What's a broker supposed to do when the government holds that kind of data that they can't gather? They just have that satisfactory kind of rating. And to me, it's like going to a restaurant that has an A rating and just saying, "Oh, it's got an A. I can definitely dine here." And then finding out after that, well, there's a lot of things there that we can't share with you, but it's your fault for eating here.
Yeah. So I've been cautioning people not to read too much into this case yet, because this is one of the ways I think it might get overturned. And the reason is the day after Montgomery, the Texas Supreme Court came out with the Home Depot decision. And Home Depot decision in part said using a satisfactory motor carrier is okay. Like you don't have to look into it further if you use a satisfactory motor carrier. And that's the Texas Supreme Court, so two levels higher than the court that made this decision. And so I think a basis for reversal of this on appeal very well may be that the law of the state of Texas is satisfactory is sufficient. So I still think that the argument is potentially a winner, that we've used a satisfactory motor carrier, that the federal government has determined that they're satisfactory, and that may, in Texas and other states, stop the inquiry right there. So don't the sky is not falling on satisfactory yet. Now, the sky is falling because satisfactory represents roughly 4% of current motor carriers, and that we have something like 92% of them unrated. And because FMCSA has not, because they haven't had the resources or the manpower, I don't know the reason why, but we have so many unrated carriers right now that we all can't use only satisfactory carriers. There aren't enough of them. And it's part of the reason why I love the request from TIA to FMCSA about additional rulemaking on what is the standard, and help us out here a little bit, publish the list of unsafe motor carriers and give us the standard that we need to use. because quite frankly, the reason why we're all focused on these tea leaves with such intensity right now is we don't have any guidance as to what the rules are, as to what we should be doing. We're all making it up as we go along. The 202 brokers that I talked to each had an opinion about which CSA scores matter the most. Should I look at CSA scores at all? Should I look at out of service for drivers or vehicles? Should I look at every single roadside inspection and read the details of all of them to determine if it's a taillight that was out versus something more serious than that? And it would really help to have some guidance from the federal government, you know, or just to know, right? If we knew satisfactory was fine, we'd at least know that, okay, we're out of the woods on that particular one. Now what else? But unfortunately, we're left on our own, and it's a tough spot to be as an industry, and we'd appreciate any help the federal government can give us on that point. But I've been telling my clients the federal government hasn't moved on the minimum level of insurance since 1980. We all agree that $750K to $1 million of motor carrier insurance is not sufficient for the injuries and accidents that are happening on the road today. And that's part of why brokers are in the crosshairs, because Congress hasn't acted to raise the minimums in, how long is that, 46 years? It's crazy. And so I don't think government is going to save us. I hope they prove me wrong. I hope they do the right thing. I hope they give us a lifeline. But we're kind of on our own to read the tea leaves, to come up with a reasonable carrier vetting standard, to behave in a way that doesn't expose us to vicarious liability and these borrowed servant theories, while still moving freight, right? Tough position to be in, um, but brokers have always been in a tough position, and they've always thrived in a tough position. And I've been telling some of my clients, the brokers that weather this storm can weather anything. And some brokers are going to quit. Some brokers are going to say this is too much. The insurance increases in premiums are too much for me. The details of how I have to run my business are too much. Great operators are going to grow during this time period. And there's an opportunity here amongst these negative tea leaves.
You mentioned, I just want to kind of touch on that petition you mentioned that TIA did back in June, right? We asked the FMCSA for a couple of things. What was it? The motor carrier safety selection standard, and also the high risk motor carrier list. I mean, you already talked about this a bit, but how would that have changed what happened in Dallas last week, if anything?
The jury wouldn't be left to decide what the motor carrier should be doing, right? We'd have a list of, or pardon me, what the broker should be doing. That we'd have a list, that says here's what a broker is supposed to be doing, and we'd be able to run that checklist. And we'd probably file a motion for summary judgment in a case like this that said we ran the checklist, we did all of the things, so we're out, right, court? And that's what summary judgment's about. When there's no dispute as to those particular facts, we ran the checklist. Here's the evidence that we ran the checklist, and they came back fine. So our use of this motor carrier is fine. And that's the kind of certainty that I think TIA and the industry is looking for. Is if we use a satisfactory carrier, then you can't challenge our use of that carrier, right? And if we use, maybe who knows how FMCSA would come back with a standard, but maybe they say, as long as you're not over two threshold percentages for CSA scores, the carrier is also fine. You can use an unrated carrier that's not over two of the thresholds, maybe. Who knows what they would come up with. But if we had that, if we had their statement of these carriers are fine to use. Now, I understand their position, right? If they give us that list of unsafe carriers, every single one of those unsafe carriers is immediately out of business. And they're worried about things like that because every single one of those carriers will sue them. And I think every one of those carriers should be out of business. So I have no problem saying bad actors, and people that aren't doing a great job on our industry should move on to another industry. But I do understand the catch-22 that FMCSA finds itself in, where they don't want to publish some of this information because it would be turning off those carriers effectively.
Yeah, definitely. So I want to get another member's question here. I know we have you for a short period of time, so I just want to make sure we touch on a little bit of everything. But someone actually brought up a good point, which is the concept of like your hard work working against you sometimes. So, short of Congress acting, are there realistic steps a broker can take in 2026 that materially protect them from negligent selection and vicarious liability claims? Or have we reached the point where almost, and you've already touched on this a bit, but where almost any carrier selection, prevention, or load management practice can actually be turned against you and used as some form of negligence in a serious crash?
So I worry about some of these questions that conflate and combine the issues. So let's take them separately, right? Let's say negligent selection. Certainly doing nothing and selecting a carrier with a terrible history, right, is going to lead to negligent selection claims. And so doing nothing can hurt us. Doing too much, let's say you set up a rule set and you say, I'm not going to use any conditional carriers, I'm not going to use any unsatisfactory carriers, I'm not going to use anybody that exceeds 65% in hours of service or unsafe driving on the CSA scores. um, you're just making a rule set that doesn't lead to vicarious liability, right? That's just rule sets about selection and negligent selection. And in negligent selection, we're basically arguing we have a reasonable standard, we applied that reasonable standard, we did it here. And I'm telling my clients I'd love some evidence saved in your system of when you did it and what the results were when you did it. So that 2 years from now, when we have a lawsuit, we can look back to what it looked like when we looked at them, not what it looks like when we're in front of the jury, because everything looks worse 2 years from now. Carriers always look worse a couple years after their collapse. Um, and so on the negligent selection side of things, I would do something. I would definitely have a vetting protocol. Now, I can't stress this enough. If you have a protocol, you have to follow it 100% of the time. You can't build something that you can't follow, because nothing is a better roadmap for a plaintiff's attorney than your own document that you didn't follow. That will be blown up, 6 foot by 10 foot and held up in front of the jury. And they'll say, this is your procedure, right? And you didn't do number 2, 3, and 4. So make sure that you don't build a system that you can't follow. But for carrier vetting, you want to do something. You want to be able to argue that what you did is reasonable. For vicarious liability, you want to make sure that you're not controlling the exact way that the motor carrier does its business, and that you're not influencing the route, the exact details of driving the truck, the when, the where, and the how. Um, and so you can do too much. I did have one client call up and say that, well, I've been reviewing the 10-year driving history for every one of my motor carrier's drivers, and I put my head through my desk so fast, like, please, no, stop, like, do not do this. This is too much. And I understand that you're trying to do something and you're trying to be active, but talk to your great, you know, legal counsel. Make sure you're using somebody in transportation. Talk to your insurance companies. Make sure, I can't stress this enough, especially with our smaller and our growing medium-sized brokers that have used their insurance broker that's just down the road that they know. Transportation specific insurance brokers are invaluable. They can tell you what kind of coverage you have. There is coverage out there for legal liability for brokers, which can include vicarious liability. Make sure you understand whether you have one of the policies that covers this stuff, because in my mind, a lot of you are doing this exactly right. You're already doing this exactly right. And you're just going to be defending that what you're doing now is reasonable. And one of the best things you can get from insurance is cost of defense coverage. And so make sure you understand whether you have cost of defense coverage for vicarious liability claims and for negligent selection claims as part of your broker liability coverage. Um, and if you're using Joe Schmo at State Farm down the street, like for commercial business coverage, right? They might have been able to place an okay product, but they're not going to be the same as some of the people that are some of the TIA members, like Reliance or Howden or uh, any of the transportation specific people out there, Logistic Q, or however you say their name. Uh, they're gonna kill me for butchering that one. Uh, but you really don't want to be questioning the coverage that you have once there's an incident. You want to know in advance. I've got cost of defense coverage. I look at cost of defense as the biggest exposure for our industry right now. For a minute, and I mean 2 years, we're all going to be defending ourselves in these cases as the tea leaves develop. And during this window, nothing is probably more important than cost of defense coverage.
You were talking earlier about obviously following protocol, right? And that's really the main one of the main tools brokers have is making sure that they're following what they have set before themselves to the letter. When they're looking at their kind of carrier selection agreement and things of that nature, what kind of language actually kind of that they don't even realize might be hurting them in facing a case like this, rather than actually helping them out?
Yeah, I mean, in terms of carrier selection, whatever their protocol is, I've seen some that are so detailed that you could never follow it every single time. And when developing those, I talk to my clients about some of these things that we put into these protocols need to be the statements that we make to our team when we're teaching them, not a bullet point on the page. Right. And so, like, I've seen broker protocols that say 100% of the time, do this, never do this. We absolutely cannot behave in this way. Right. That's the statement that needs to not be on the page that we need to communicate to our team when we're training our team. And it's good to have those kind of statements in there, but you need to look at these protocols and say, put your plaintiff's attorney hat on, pretend like you're a plaintiff's attorney for a minute and say, what would I do with the language that's on this page? And the same thing for broker carrier agreements, right? Like broker carrier agreements oftentimes have all kinds of stuff in them that brokers think is helpful. I saw one the other day that had a 1 minute window, right, for the timing of delivery. And that's going to be used against that broker in any case where somebody drove past hours of service. And we have to think like that. We have to say, is this helping us? Or is it hurting us? And I ask the brokers that have 1 minute windows in there, right? Have you ever sued a motor carrier to enforce this 1 minute window? And could you get a court to even go along with you on that? Would you ever sue them to enforce this? No, then let's take it out, right? Let's find a different way to achieve the business result that you want, instead of just handing some contract language to a plaintiff's attorney that says they have so much direction and control, they control them down to the minute.
So one last question here. I think a lot of people are still curious, like where things are going to land post Montgomery. This is tangentially related. It's not an exactly result of that, as you discussed before, but kind of something to leave us with. What are some thoughts you have about the landscape, the legal landscape at this point post Montgomery? Is there anything you want to leave people with? I think some people came in and they thought, oh, this is going to be the apocalypse of smaller houses, of smaller shops, and then they see a massive judgment against a big one, so they think, oh, the plaintiff's lawyers are going to go after the big guys because there's more money to be had there. Is there anything that you take away from this, or is there anything that you can kind of leave listeners with when it comes to this case?
Yeah, I would say we're fooling ourselves if we think they're only going to go after the big ones. We have 350 broker clients out of our 500 total clients, and 32 of them have been sued already, all different sizes, large, medium, small, post Montgomery, for highway accident cases. So everybody's in this together. Um, the other thing, it's not the gloom and doom that we're all worried about. This case is going to play out over the next several years. I think the prediction is that if this one goes to the Court of Appeals and then ultimately the Texas Supreme Court, it'll be 2029 or 2030 before we have any finality in this particular case. And so, little bad news today or this week from this initial decision, but we're not going to know for a little while. And it's kind of like Werner and their bad case in Texas, right? Like that $100 million number sat out there for years before it was ultimately overturned on appeal. And that case is still going on. And so, it's a little bad news today, but it doesn't really determine a whole lot, and it's very likely to change as it gets reviewed on appeal and be above. I tell my clients, let's come up with something that we can defend as reasonable, something that we can do, something that we can defend as a reasonable carrier vetting standard. That's our Montgomery strategy. And our vicarious liability strategy is let's do our job, let's not do the motor carrier's job. And then back our risk with insurance to the extent that we can, and make sure that we have cost of defense coverage so that we're not bleeding to death with 1,000 paper cuts because of the cost of defense in all of these cases. That's what we can do right now. And keep our head up, move freight first. Nothing else matters if we don't move freight. It's been a rough three or 4 years in terms of freight numbers. It's starting to look better. Let's take advantage of that. Let's seize the day. Look at our contract provisions. I hate to mention this, but if the broker transparency rule really does come down in the next month or two, imagine how powerful it would be to have a provision in your carrier contracts that said, if we're forced to give you any information under the broker transparency rule, you can't share that information with anyone else. That would keep it off message boards. That would keep motor carriers from getting information and selling it to clearing houses that might aggregate that data. And so we may not be able to prevent disclosure if that rule comes out, but we sure could put something in our contract that limited where it went. And so a lot of this is thinking ahead and being creative and saying, like, what's the problem of today and what's the problem of tomorrow, and how am I going to get out in front of both of those so that I can actually grow my business, in an area, in a time period where the operators that aren't quite as good as me are worried about shrinking or leaving the industry.
That's a perfect place to end it, I think. Craig, really, really appreciate you kind of turning this around real quick on us. And thank you also to the listeners for sending in questions. Also, reminder for everyone, this was a conversation about developing case, not legal advice for your business. Craig Helmreich, you're the founder of Helmreich Law. Craig, where can people find you if they want to follow this case?
They can go to helmreichlaw.com, LinkedIn, Google me. I'm easy to get a hold of. My cell phone number's on our website, so give me a call. We can chat.
Perfect. Well, thank you so much once again, Craig. And thank you again to everyone for listening. As always, don't forget to rate, review, and subscribe on Spotify, Apple Music. Give us a like on YouTube. Other than that, I have been Merritt,
I've been Patrick.
and this has been Freight Beat. We'll talk to you next time.